Now, during the pendency of the writ appeal, the matter was amicably resolved, my lord. If your lordship kindly comes to page 14, my lord.
Yes.
Rather, lordship, I direct lordship to directly to page 15, my lord.
Yes.
Sentence starting with when the case was called upon. Page 15.
15.
15, my lord. When
the case was called upon, yes.
The last session, this court passed the following order.
Yes.
The court has referred the parties for an amicable settlement before the registrar, my lord. Lordship turns to page 16.
Yes.
When the appeal is called upon, the third sentence from the top.
Yes.
When the appeal is called upon the second time, learned counsel for the parties have informed us that the matter has been amicably settled between both the sides.
Yes.
As per the settlement arrived at between the parties, already an amount of rupees 50 lakhs has been released to the appellants. Appellants are the wife and second wife and the son.
Second wife.
Second wife and the son. Balance amount of rupees so and so which is lying with the IOCL would be shared between the parties in the following manner. So there is no dispute on this. 30 lakhs was paid to the original writ petitioners, respondents in the writ appeal, madam. That is the daughters. And the remaining 21 lakhs was paid to the appellants, that is the wife and the son. Now, the difficulty has arisen how, my lord, this amount has been released. Now, if your lordship turns to page 7 of the IMLR, 8 of the IMLR.
Yes.
And this amount of 2,74,000, this on account of interest accrued, my lord. This is lying with us. We could not bring it to the notice of the honorable court earlier. Now, how to release this amount? This is the difficulty.
You can make it same ratio.
That is what we are praying. But without directions from this honorable court, my lord, we did not do it on our own, my lord. 70-30 is the ratio. That is our simple prayer.
Is Mr. Bhattacharya available here? No, you see, that apart. For the purpose of modification of the order, your brief technically remains with you. Here you see, they are wanting to pay money. So any objection in receiving money? I don't think there should be any. So, no, I'll record your statement, but and who appears for the other?
And Manojit Biswas has appeared.
M. Biswas. So what we'll do is that we'll give a scroll for Mr. M. Biswas, so that otherwise I'll have to issue a notice. Unnecessary, there will be a delay again. Scroll for Advocate M. Biswas. M. Biswas.
If I have his number, I'll also give him a call.
Let
me take it up sometime.
After some time. Just inform Mr. Bhattacharya that this is what we are proposing.
I'll also give him a call.
If it's a normal objection, then nothing to do. But if there's a serious objection, then he may. No, not that. But if there's a normal objection, nothing big. But if it is a serious objection, then he may address us. Okay.
Item 2.
The last order might be reflected, and I just checked up the records of it. The reference file to use flag N of the reference file, where the report has come from the DLSC. Now, the DLSC has been with not to grant any amount of compensation to the victim or her legal heirs. Let me just place the facts of the report. What has happened is that the victim had a first husband. From that first husband, she had two children, two sons. Now, one of them is right now aged 22 years, and the other one is 19 years. And the one who was 22 years, his name is Shiva Garg. There's no whereabouts of that particular site. And the one who was 19 years, Kundan Garg, he allegedly is now daily wage earner and he stays separately with the first husband of the victim here. So, right now, the DLSA, after this entire inquiry, has deemed it fit not to grant any compensation. Now, if the lordship would want to perhaps grant any, if at all, any compensation is liable to be granted to the children from the first husband, because of the second husband who has killed them. From the second husband and the victim, there were no children. So, and now they go for adults as well. Although the definition, Rachna is taking up the provisions as per the victim compensation scheme, section 2F, victim includes the legal heirs of the victim. So.
Technically, they were, you see, stepfather is a recognized, what you call, relationship.
But the DLSA does the medical, know why? Because I'm not appearing for the DLSA. I'm only appearing for the state legal service authority. And DLSA is not deemed it fit to grant any compensation. Perhaps your lordship may pass any particular order to that effect as to why no compensation has been granted. Why will be, or maybe they have just conducted the inquiry and did not go any further without leave of this authority. Perhaps that could be the reason why.
So technically, we'll have to issue a notice to the DLSA to,
Again, because the DLSA has only conducted the inquiry
Hmm.
and has not deemed it fit to grant any compensation. So Lordship, kindly issue a notice to the DLSA saying that appropriate compensation should be granted. And then the state legal services will naturally release the funds.
May I please your lordship? Lordship, I'm on behalf of this.
yes.
I'm on behalf of these children and this council since in election before Kotha submitting to the council.
Okay. Because we'll have to proceed with the appeal hearing also.
And take care of this. Then thereafter.
No, this is something which is what you call sidetrack, but appeal will have to see. But in this, we are issuing a notice. Will
In fact, as per order dated 22/8/2022, you will find that on page 2 of the order, it reflects that the report shall be placed so that necessary orders can be passed regarding payment of.
Yes, yes. Yes, yes. Yes. Both sides are represented. Mrs. R.S. Chaudhary, learned counsel appearing for the Asalsa, has brought to the notice of the court the letter dated 22/12/2023 issued by the ASLSA to which an inquiry report conducted by the DLSA Tinsukia, so it's PLA, is also brought to the notice of this court. Indicating reasons why the DLSA Tinsukia was not inclined to release victim what is it called, victim?
Under the victim, Assam Victim
Compensation under the Assam Victim Compensation Act. Next, we deem it appropriate that a notice be issued to the DLSA Tinsukia so we permit the learned standing counsel for Asalsa to hand over a downloaded copy of this order to the Asalsa so as to transmit this order to the
by the state government council. Any state government council can take notice for DLSA.
okay. For honor transmission to the DLSA Tinsukia, first of Morova. Written notice we also issued to the state, to the office of the senior government advocate, Assam, for appearing for in the matter. The registry shall forward a downloaded copy of this order to the office of the senior government advocate, Assam, to bring it to their notice. Full stop. This issue would be taken up for consideration on the next date of listing. So we are passing this order now. When after this comes, scheme. Okay, scheme.
And the name of the government advocate Assam is also reflected.
Okay. The registry shall reflect the name of G. Assam and the cause list while listing the matter next. We'll take it up after some time. Mr.
But I am not.
Yes. Mr. Bhattakur and Mr. Biswas were here. Yes. In this matter, they are ready to, they have some interest with them. And they want to pay it. So I was told that you don't have the brief right now, but since it's an extension of the matter and they are wanting to pay, they are not wanting something from you, they want to pay you something. So we'll allow it. Okay. In the same proportion, same proportion. Okay.
Say that whatever amount is with us, because there may be further interest which is accrued, because this is the IA is of 2018 matter. So maybe.
But should we preempt lawyer from appearing in the court by framing our orders in such a manner that we lose an opportunity to address us? Can we do it or should we do it? Can we do it is yes, but should we do it?
In a rare case where the other side advocate is more happy than the petitioner's advocate.
You see, ultimately we say it is the goodness which prevails. So this is one of those classic cases where goodness has prevailed. And therefore they have come forward to offer this money. So entirely this Kali Yuga has not come. Yeah. There are good people around. Had Mr. Endekar learned counsel for the for the applicant. Also heard Mr. S. Bhattakur, learned counsel for you will be for opposite party numbers 1 and 2, as well as Mr. M. Biswas, learned counsel appearing for respondent number
3 and 4.
3 and 4. Next para. It may be mentioned that the learned counsel for the opposite parties number, sorry, it will be opposite parties here. Opposite parties number 1 and 2, as well as opposite parties number 3 and 4, both submitted that the brief is no longer with them. Next para. Be that as it may, in view of the nature of prayer made in this application, we hold that the opposite parties number 1 and 2, as well as the opposite parties number 3 and 4, shall continue to be duly represented by the learned counsel in view of the provisions of order 3. Explanation to explanation to rule 4 of order 3 CPC. Next para. By filing this application, the applicant, which is a public sector undertaking, has brought to the notice of the court that a dispute had arisen between the opposite parties number 1 and 2, as well as opposite parties number 3 and 4, with regarding their claim in respect of shares of terminal benefit of their late predecessor in interest, namely late Gauri Das, who was an employee of the applicant. In course of the proceedings, the matter was compromised between the two sides, and accordingly, the matter was disposed of by order dated 24/5/2018, passed by the division bench of this court in WA 122 of 2018. The effective order with regard to this settlement is reproduced below, page 16. Next paragraph. The learned counsel for the applicant has submitted that as per their record, that some interest has accrued on the balance terminal benefits of late Gauri Das, and as per their record, the interests as on the date of their calculation has amounted to rupees 2,74,480. So it is submitted that there is also every likelihood that by the time payments are made, there might be some more accrual of interest. Full stop. Accordingly, as there is no order for appropriation of interest between opposite parties number 1 and 2 on one side and opposite parties number 3 and 4 on the other side, comma, the applicant has filed this application for an order of this court to release interest on the terminal benefit to the said parties. Next paragraph. In view of the nature of prayer made, comma, taking note of the fact that the opposite parties number 1 and 2, as well as opposite parties number 3 and 4, have arrived at a settlement which is indicated above, comma, the court is inclined to allow the applicant, i.e. the IOCL, to release the interest which has accrued on the terminal benefits in the same ratio as the principal terminal benefit was appropriated and appropriated or divided and paid to the respective opposite parties number 1 and 2, as well as opposite parties number 3 and 4. Full stop. The next paragraph, in disbursing payments, comma, if there is any fraction, comma, we permit the applicant to round it off to the nearest and nearest whole amount. Whole amount. It's not a whole amount. It's something
Whole number.
whole number. Whole number. Next paragraph. In view of this, application stands allowed and disposed of. Next paragraph. We also put on record appreciation on towards the applicant and their concerned officers who have found out dues payable to the deceased employee and paid and has offered to release the amount to them.
While your lordship was discussing, I said that an appreciation is coming. I told him that an appreciation is
No, we should be,
Some divine intervention.
no, we should be,
Able to read the future, madam.
no, we should be cautious. He can do lip reading.
Item 3.
That's why, we, in our, the religion which I follow, the priests and saints, they are required to keep their, what do you call this,
Face cover.
mouth and nose covered. Yes, item 3. Yes.
Yes, I am appearing as amicus curiae in this case. I have received the paper. Just one thing I am pointing out here, your lordship, that I have noticed that at the relevant time of probably he was a juvenile.
Is it?
From 3:30, your lordship will find
313.
that your lordship will page 46.
Page
46.
46. $20.
20 years, date of recording, your lordship will find third line from 11th January 2021.
Yes.
And your lordship will find that date of occurrence is page 1 of paper book, 4/12/2015.
4/12.
2018.
But there must be some materials with regard to the age somewhere.
It is not, I have not found any documents. And the learned legal aid counsel who represented him in the trial court, by name I know her, so I tried to contact her. And she said that here the informant is mother, the victim is his sister, so family members are not cooperating in this case. So he or she cannot produce any document.
But then we'll have to ask the district judge to make an inquiry. We have the LCR here.
The paperwork is put there.
No, in the LCR, there may be some disclosures. That's statement the 20 years. CD
1611.
161. It's okay. Last page. Mr. A. Ahmed, learned counsel for the learned legal aid council. What's it? Amicus Curiae. Learned Amicus Curiae. Which page is that? 313?
Page 46.
46. Has brought to the notice of the court the statement of the appellant accused when he was examined under section 313 CRPC on 11/1/21, wherein he has declared his age to be 20 years. Accordingly, it is submitted that the date of occurrence was 4/12/2018, which would make which would mean that on the date of occurrence, the appellant accused was a minor. Next paragraph. We have noticed from the LCR received by this court that the IO, while recording the statement of the accused in course of investigation, had recorded the age of the appellant accused as 20 years. Be that as it may, as the learned Amicus Curiae has taken up plea of juvenility, we deem it appropriate that the matter be inquired into by the learned district judge, Kokrajhar. Okay. Learned. Session judge. The judge is my session judge or special judge?
Page 51.
51. Is my special judge, sorry, not district judge, it will be special judge Kokrajhar. Next paragraph, the registry shall send back the LCR to the court of learned special judge Kokrajhar, so as to enable him to conduct so as to enable an inquiry to be made. And after inquiry, the learned special judge Kokrajhar shall return back the LCR to this court. Along with the report. Stop. I'm giving you 6 weeks. We grant, we allow 6 weeks time to the learned special judge Kokrajhar to make an inquiry. If, no, full stop. The learned district judge, sorry, no, learned special judge Kokrajhar is also permitted to take the assistance of the jurisdictional police station to make an inquiry and if required to record evidence. Next paragraph. We also provide that in the event the inquiry cannot be completed within the time allowed, it will be open to the learned special judge Kokrajhar to inform this court for, with a period for extension of time. The said request may be sent to the registry through email, or being placed before this court. Said request, if any, may be sent. List after 6 weeks.
Item 4 and 5.
Yes.
As per the last order of this honorable court justice, the learned committee was directed to obtain instruction from the officer of the Panchayat police station regarding the notice, silence of notice upon exception number 2 lot.
Yes. We see that if he is not sent, we grant an extension of time. Within that extended time, he will mention the what you call that notice, the next date of appearance, and serve it, if not already served. No, that is okay, but it has to be served. Sending is something which has been done, but ultimately we are waiting the service report. It is the officer in charge of which police station?
Nazira. Nazira police station.
Nazira. Okay. Both sides are represented. Ms. S.H. Paralaned, APP, has submitted that the notice for service of the notice for service on respondent number 2 has been sent to the officer in charge of Nazira police station for onward service on respondent number 2. Full stop. Now she is awaiting service report. Next para. We hereby direct the officer in charge of Nazira police station to serve notice on the respondent number 2 within the extended time as granted by this order, and without fail to submit the service report. So we put the officer in charge of Nazira police station to notice that in the event he fails to send back the service report within the extended time, or the court may order his personal appearance before the court. Next para. You also provide that while serving notice on the respondent number 2, the next date of appearance shall also be indicated in the notice. Next para, the date of appearance is date of appearance and listing of the matter is fixed on. Tell a date.
Any date.
It's 23. We fixed on 9th of February. Yeah. 9/2/2024. Next part, the learned AVP shall transmit a downloaded copy of this order to the officer in charge of Nazira police station to bring the order to the to his notice.
They have taken steps to the registry lordship as per the court's order 13/12/2023. A report was called for to the registry lordship whether the service was complete, but there is no office note regarding this acknowledgement. Item number 5. Out of the same judgment lordship, 2 persons were convicted and sentenced.
Okay.
Court's order dated 13/12/2023 lordship. The report was called for regarding the service of notice upon respondent number 2. I have checked the office note lordship. There is no recent office note regarding this.
I think here also notice has to go through you. You just give the written up notices to the registry, fresh.
Lordship, in this matter, Lordship, the informant is the same, Lordship, in both the cases. If he comes in the item number 4, then the.
No, but you see, technically we'll have to issue notice because it's a criminal matter. He has to have notice of this application also. But Mr. U. Chaudhary, Learned Counsel for the appellant, and Mr. S. H. Boral and APP for the state, having noticed that steps for service of notice on respondent number 2 was taken long back, comma, we hereby provide that the learned counsel for the appellant shall submit return of notices or service of respondent number 2 to the registry of the court. Stop the registry along with the registry shall process the said notice and hand it over to the under APP for onward transmission to the respondent number 2 through the officer in charge of the jurisdictional police station, i.e. Nazira police station. Next paragraph. The officer in charge of Nazira police station shall serve notice on respondent number 2 and transmit the service report positively to the court through the office of the public prosecutor Assam at Guwahati High Court. So the notice is made returnable on to 9/9/2024. Post of the land APP shall send a downloaded copy of this order to the officer in charge of Nazira police station for service of notice and return of notice to the court. List on 9/9/2024.
Public.
Item 6.
Yes, Mr. Gupta.
I have received the department, my lord. As per office, there is 8124, my lord. It will be solved from respondent number 2.
Notice is served. 8/1/24 notice is served on respondent two.
It's for hearing.
Okay. Mr. S. Muttal and the counsel for the appellant has brought to the notice of the court the office note dated 8/1/2024, indicating that notice has been served on respondent number 2 and ID card has been received back. So none appears on call for respondent number 2. Next paragraph, Ms. S. H. Boral and APP is present. Next paragraph, as the paper book is ready, let this matter be listed for hearing in the month of February 2024.
Item 7.
Yes,
As per office note dated 18/1/2024, reflected we have not taken steps, but my lord, we have taken steps twice.
you have the acknowledgement. রিপ্লাই করে দিও Mr. A. Gayan, learned counsel for the appellant, has brought to the notice of the court that white document serial number 2 of 2023 dated 23/11/2023 no, no, not that. First will be document number 1 of 2023.
No, we have taken steps on 31/7/2023.
Yes, sir. Which was received by the registry on 31/7/2023, as well as by document number 2 of 2023, received by the registry on 23/11/2023. Steps has been taken on 2 occasions for service of notice on respond number 2. Full stop. Copies of the said acknowledgement has been handed over to the court, which is made a part of record. Full stop. The registry shall track the steps taken and after processing the notice, the same shall be handed over to the to Miss. Your name and thus under APP for onward service on respond with 2 through the jurisdictional which police station? Hajo police station. Next, the officer in charge of Hajo police station shall ensure that upon service of notice, the service report shall be sent back to the court to the office of the public prosecutor Assam at Guwahati High Court for placing it before the court. Next, the learned APP shall also transmit a copy of this order to the officer in charge of Hajo police station to bring it to his notice. List on 16/2/2024 awaiting service report on respond number 2.
I am learning public prosecutor have not filed their objection.
Okay, I write objection if any in this application be filed prior to the next date of listing, list on 16/2/2024. What says the representative?
Same age. User also.
Yes,
Already admitted by order in the 4/8/23.
you have appeared for respond number 2. We'll fix it for hearing then. Oh, achha, this paper book is not yet prepared. Okay, just a moment. Just a moment. The counsel for the appellant, respond number 2 as well as the learned APP are present. The learned counsel for the appellant shall provide a copy of the paper book to the memo of appeal to the to Mr. A. Khanikar, counsel for respond number 2 within 3 days. Next para. The office note dated 27/9/2020 indicates that records have been received. So the registry shall make an endeavor to expeditiously prepare a paper book. List after 4 weeks awaiting preparation of paper book. at least after 4 weeks.
Item 9.
Respond number 2. Okay, heard Mr. N. Burman, counsel for the appellant. On the prayer made by Mr. R. K. D. Chaudhary, learned counsel for respond number, learned, what is the agency? Learned DSGI appearing for respond number 2. Comma. How much time? 2 weeks time. 2 weeks time, 2 weeks further time is granted to file objection in this matter. So, 1 and 3 is by APP, Miss M. Das, N. Das, learned APP. No, he's the informant. Informant would be the Assam police who has registered. Is it Assam police or it is you and Nia? Assam police, huh? So she will represent, there is no difficulty with that. Ms. N. Das, learned APP may also file objection if so advised within the prior to the next listing. But 2 weeks give a date.
In between lower city and lower court status may be confirmed.
They'll be able to tell how many witnesses have been examined.
2 witnesses.
Huh?
2 witnesses. I'm the trial.
No, it's okay, because that's not relevant. Here you are against this order of bail, rejection of bail. We are not appreciating the quality of evidence right now, correct? So only that information you have it on that day, we will take it. You know, the difficulty is something else. Because if we ask for a status report, it is the concerned judicial officer who has to sit down and then make a report and send back. So in fact, at times I think it's a wastage of their time to make a report, inform the court about the status report, then send. These are some clerical work they have to do, correct? So I try to avoid as far as practical. So as far as practical, I try to avoid it. If it's unavoidable, then we do that.
Two weeks this. Date given. 9/2.
I'm episode.
Next, in the court permits the learned counsel for the appellant as well as the respondent number 2 to inform the court about the status of trial on the next date listing list on
12/2.
Item 10.
yes, item 10 is not there. This is an early hearing application. This 23 matter. March 2024. None present call for the applicant. However, Ms. Andas and APP is present. Next, this interlocutory application has been filed for early hearing of the corrected appeal. It is projected that the trial relates to the year 2009. Next, accordingly, we deem it appropriate to allow this application. List the connected appeal for hearing in the month of March 2024.
Seven.
Now I said the item 1 and 2 case. Item 1 and 2. Item 1 or 2 was adjourned, na? Legal aid counsel, she is here. After that, call that item. Pass over that item 2. Mm. Yes, item 11. Yes.
1,283 days delay, Lordship.
What is the ground?
Ground, Lordship, I am appearing as a legal aid counsel, Lordship. The petitioner has, next one is the letter of the wife of the petitioner to the Honorable Chief Justice, stating that he was here in Sriram jail for 10 years and then subsequently he was transferred to Madurai jail, Lordship. Although it is not here, but I have a verbal instruction that he engaged someone, but it was not filed. But as it is not provided any document regarding that, Lordship, so I have not taken that ground on my petition, Lordship.
Issue notice then. Formal notice has to be issued. You issue formal notice, you see what can be done. And in the meanwhile, you also take instructions with regard to his the place where he's presently lodged. She is saying that initially Kokrajhar,
Now
then
he is
transferred to
Madurai.
Madurai. Heard Ms. B. Sharma, London Council, London Legal Aid Council, for the applicant. Also heard Ms. Andas, London APP for the state. Next paragraph. By this application under Section 5 of the Limitation Act, the applicant has paid for condoning the delay of 2283 days beyond the period of limitation in filing the connected appeal. Next, the Legal Aid Council has submitted that the matter was referred to the Guwahati High Court Legal Aid Committee after receipt of a letter from the wife of the applicant by the office of the Honorable Chief Justice. Wherein it was projected that the applicant was in jail for 12 years. Initially, he was lodged in Kokrajhar District Jail. And for last 10 years, he has been transferred to Madurai Central Jail.
He was in Kokrajhar for 10 years. For last
Achha, Kokrajhar he was for 10 years. He was in Kokrajhar for 10 years and thereafter transferred to Madurai Central Jail on humanitarian grounds. It is also projected therein that the wife of the applicant does not have any document related to the said case and that she belongs to a very poor family. And though she had appointed her own lawyer, she
What a complete sentence logic. Where is it?
but and that she had also, first of, she has also stated that she has appointed her own lawyer in the matter. Full stop. It appears that the sentence is incomplete. But it can be inferred that she has no information about the appeal, if any, being filed. Next para, accordingly, court is inclined to issue notice to the state on this interlocutory application returnable on how much time? 9th of February 2024. So objection will be filed by then. List on 9/4/2020, 9/2/2024.
Logic, as it is 3-0, so possibly information may not be necessary.
They are not, they are party here.
I have made party, but
Okay, okay, well, তার উপর দিও, that issuance of notice on respondent number 2 is dispensed with for the time being. Stop. However, the court leaves it open to exercise discretion to issue notice on the respondent if deemed appropriate at a later stage. List on transfer. Why? Enable him. The item to complete করা ছিল, এটা part order করে প্লেতে রিলিজ করে দিয়েছিল। Order to-
কোথায় দিয়েছিলাম
Accordingly.
ব্রেক ব্রেক লোগো ব্রেক করেছিল ফাইল কোথায় দিয়েছিল ঠিক আছে
ঠিক আছে, বাতিল। We'll take a short break and come back again.
দুই নম্বৰটো ফুল দিছে হৈ যোৱা নিচিনা লাগে এক নম্বৰটোহে হেৰি হৈছিলে এইটো এমবি চাচং মাতিব দিছিলে তো সেইটো কাৰণে টাইমিং কৰা আছিল তোৰটো কি ভুল এতিয়া মই মানে আচ্ছা আহিব আহিব 5 মিনিট মুন্না আছে নেকি মুন্না পালে হৈ যায় তো হ'ব হ'ব মাতিছেতো মই বুজি পোৱা নাই এইটো
কিন্তু এটা 1 2 3 করবো না যদি আপনার লাগে যে এটা রিসার্চ ওরিয়েন্টেড বলতো তারপরে টাইম লো একো নকম এটা মানে সিকিউর এটা আপনি একাজ সালে আপনি পাবেন
দহ নম্বৰটো আইএটো এলাউ কৰিছে মাৰ্চত মানে মেইন যিটো হেৰিটো এপিলটো মাৰ্চত ডেট দিয়া নাই
Yes.
Sorry, Lordship, I just-
No, it's okay. We have sent this this issue of compensation. We have directed notice to be issued. And as far as the appeal is concerned, what do you have to say?
If, in this case, this is a case of 302.
And the informant, in fact, is not an eyewitness to the incident. And in fact, if we read his deposition, 164 statement, appears to be a hearsay witness. And
No, we'll have to, this is for hearing. But this has come for orders only for that reason, that the DLSA matter. Otherwise, this will go for hearing. Paper is ready.
I would say
Okay. Mm. When have we fixed this matter?
In continuation with the part.
When we have fixed this matter,
No, it's not even.
date has not been given. Just like two lines, half dictation has already been given, huh? You see that? Notice is made returnable on 16/2/2024. Next paragraph. In the meanwhile, as it is noticed that the paper book is ready, list the matter for hearing on the same day. Next list on 16/2/2024. You in the first part, you also had Ms. B. Chaudhary for the amicus curiae for the appellant, and Ms. S.H. Baran, the APP for the state.
Item 12 and 13.
Somebody has taken dictation, huh? So this will be reality.
I am appearing in item number 12 and Mother Ganesh Khan is appearing in item number 13.
Yes.
Here, two appellants are, two persons are convicted, Lordship, under section 302 and 3762G.
Just a moment. In criminal appeal 252, you are appearing.
Yes, Lordship.
And in 184, you are appearing. I am like a jailer. I would note by numbers, not by name. Yes.
So here today, Lordship, the facts of the case is similar to the case which I have argued on last Friday, around last in Tuesday. Lasting fuel, Your Lordship, similar to that. Your Lordship. Here Your Lordship will find FIR is at page 2.
Yes.
Here, may I read that? Humble submission is that at about 7 p.m. on 23/3/2012, that is on Friday, Srimati Resna Dole, daughter of Sri So-and-so, went missing while she was enjoying the cultural night held on the occasion of Aliyah Ligan festival at Pulajan, Tingeri. It is a matter of utmost regret that we have found her lying dead on the national highway in the morning on the basis of the information given by Lord Gamabura of Gwelua Model Village. I suspect this to be a pre-planned murder. So the FIR was lodged by her father and no person is named in the FIR. And initially the FIR was registered under section 302, page 5, your lordship will find receive and registered as so PS case under section 302. Because when her dead body was recovered and in the inquest also your lordship will find there was no sign that should show that she was sexually molested. That part was not there, even in the inquest report also. So subsequently 376 was added. And on what basis I will place the question. Page 10 is the evidence of PW1 information. Mary. I do not know the two accused persons present in the door. This is Resna Dole was my daughter. The incident took place on 23/3/2012. On the night of the incident, Sneha came to Pulojan to watch Aliyah Ligan festival. Onu Dole, Dipti Dole, Saurabh Dole, and Sobita Dole were with her. All others returned home after watching the function. As Resna did not return, we asked them about her whereupon they replied that Resna had been disappearing since 8:30 p.m. The following day, the village headman of Gelua informed that Resna's dead body had been recovered. On receiving the information, I went to Gelua. I saw injury marks in the backside of the head of Resna's dead body. I identified the dead body to be Resna. I found police at the spot. I lodged an Azahar with Sisibor Police Outpost. Exhibit 1 is the Azahar wherein Exhibit 11 is my signature. Police questioned me and recorded my statement. The SDC held inquest on the dead body and prepared inquest report. Exhibit 2 is the inquest report wherein Exhibit 21 is my signature. Police took away Resna's dead body for postmortem examination. Later, I came to know that two persons, Numal Gogoi and Deepak Gogoi, had killed her. My daughter-in-laws, namely Onu Dole, she is not examined, Dipti Dole, she is not examined, and Sobita Dole, she is PW6, Sobita Dole, told me that Deepak Gogoi had come down from the stage and called Resna away to the market outside. After a while, Resna returned and giving daughter-in-law Chanas 2 months. She left the place saying that she need not look for her. They need not look for her. My daughter-in-law told me that she had gone to get married to Deepak Gugoi. Police seized Reshna's broken mobile and the SIM card. Cross for Deepak Gugoi. So just before reading the cross, just one thing I'm pointing out before your lordship, that your lordship was saying that she went with, allegedly went with Deepak Gugoi, and then she returned. And this fact your lordship will find subsequently from other witnesses also. Cross for Deepak Gugoi. I was in Silapathar on the night of the incident. Learning about the incident over phone the following day, I came home and got to know about the incident from my daughter-in-law. I met my daughter-in-law Anu Dole before lodging the Ejahar. I did not mention in the Ejahar whether my daughter-in-laws had told me as I had broken down mentally. While making statement to the police daroga, I did not tell whether I had been told by my in-laws, by daughter-in-laws. So that part, whether she went with Deepak Gugoi or not, that part is not there in police statement as well as in the FIR, which he admitted in cross. It is not a fact that my daughter-in-laws did not tell me that accused Deepak Gugoi had taken along Reshna with him. It is not a fact that Deepak Gugoi is not involved with this case. It is not a fact that I have adduced false evidence. So about Deepak Gugoi, he is speaking for first time in the court. Now, page 12 is PW2.
Well, this PW1, he's the father.
Is the part. PW2 is the brother of the deceased. Harry.
Yes, please continue.
I do not know the accused persons who are present in the dock. Reshna Dole was my sister. One night, 2 years ago, Reshna went to watch a function but did not return home. The next day, on getting information that a girl was lying dead on the road, I went there to have a look at the dead body. There, the dead body was lying soiled with blood. It was Reshna's dead body. Police took away Reshna's dead body for postmortem examination. Police arrested 2 persons, namely Numal Gugoi and Deepak Gugoi, in connection with Reshna's death. I have only this much to say. Reshna's companions who had gone to watch the function know about the incident. Please call them as witness. So cross-examination declined. PW3, page 40. I do not know the accused Dio. I do not know complainant Tuniram Dole. I do not know Reshma Dole. On one night in the month of March 2012, as I was sleeping in my house, one person informed me over phone that a girl was lying dead on National Highway 52 near Gelua village. I immediately went to the spot. I saw a girl lying dead at the place of occurrence.
In fact, this few PWs you can omit. There's 1, 2, 3, 4, 5. I don't find there.
The 5 is important. 4 we can skip closely. 5, page 18. I know both the accused persons. Page 18, I am reading.
Because this man saw you, I think, with the victim girl.
That is in examination in chief, but in your lordship, in the cross examination, he admitted that police, suggestion was put to him that in 161, he did not state about the state facts, about the present appellant Deepak Gupta, which is confirmed through IO at page 33. In page 19, your
But we'll
lordship
come to that when we evaluate the evidence, because you see, 161 is something like examination in chief. He will, the witness will say whatever his police is asking him. If the police has not asked him, that IO has not asked him certain questions, that will not come in 161. So therefore, evidentiary value is one part, the contradiction is another part. The lack of statement may not amount to contradiction in many cases.
Here, lordship will find that the incident occurred on 2012. Thereafter, his statement was recorded, FIR filed, nowhere he mentioned about mining. And when in the year 2015, he came to court for deposing before the court, then only he named first time mining and mentioned mining. After 3 years. Because if he said the name of other accused person or other persons, he could have named me also. And
I can't say about you, but I'll tell you something. You see, when let me say that I go at a, say, a marriage party. I speak to someone in the marriage party, then on the next day, the person, another person who was there, supposing you are there in that party also, you ask me this, say you on that day, yesterday you were speaking to some person, who was he? I won't recollect with whom I was speaking. Correct. You tell me the place that you were there near this marriage hall, you were eating and then you were speaking to someone. Who was that man? I won't recollect. But after some days, when I see this man with whom I was speaking, then I will recollect, oh yes, this man which I am speaking was Mr. S.S. Bora. Because see, at times, it's a fallible memory where I may not be able to recollect with whom I was speaking. It may happen to anyone. And it happens to me usually. When somebody asks on the next day that you are speaking to someone on the next day, who was he? I won't remember. But then after 10, 15 days, I see Ms. Bora, and then I realize, oh, that day I was speaking to her. Correct. So if immediately, if I don't give a statement of what has transpired, we'll not be able to recollect what has happened. That is one. So we'll evaluate it when it comes.
the first line, in an examination in chief, he said, I know both the accused persons. In cross-examination, lordship, I am reading. On the day of the incident, at first accused Deepak and girl went somewhere on a motorbike. Later, both of them returned. So this is what I was pointing out to lordship, that it is in the evidence of PW1 also. That initially they went, subsequently they returned. It is a fact. It is not a fact that after returning accused Deepak did not go out with the girl again on a motorbike. It is not a fact that I did not state to the police that I had seen accused Deepak Gogoi out with the girl.
But this ownership of the bike is not, it's not come in trial.
It is not a fact that I have deposed falsely that I saw accused Deepak with the guy. Cross-examination for accused Numal Gupta. It is not a fact that I had not seen accused Numal Gupta going out with the deceased guy on a motorbike on the day of the incident. It is not a fact that I have adduced false evidence. I do not know as to how the daughter of Puniram died. Now, PW6. I know accused Deepak. I do not know the other accused person. I knew Resna Dole. Somebody killed Resna Dole around 3 years back. Resna went with us to Kulojan to watch function held on the occasion of Alia Ligang festival. Accused Deepak called Resna away when we were watching the function. On the following day, people found Resna's dead body lying on the road. In the course of investigation, police recorded my statement. So here your lordship will find that although it is alleged that accused Deepak called Resna away when we were watching the function. So whether she saw both of them prior to coming back or after that exact timing is not there. Because evidence of PW 1 and 5 clearly says that they went and came back. So whether this PW 6 saw after or prior to that part is not there. While making statement before police, I did not state that accused Deepak had called Resna away while she was watching the function. So this is admitted that during investigation, she did not disclose the name of the present appellant Deepak. It is not a fact that I have adduced falsely in the court today that accused Deepak had called Resna away. It is not a fact that I have adduced false evidence. PW 7. Page 22. I know accused Deepak. Resna Dole was my elder sister. The incident took place 3 years ago. I, along with my wife and Resna, was watching function at Kulojan. Deepak called away Resna outside, telling us that she was going to marry Deepak. Resna went away, leaving us at the side of the function. In the morning of the following day, finding Resna's dead body lying on the road, when people informed us, father and others went to the place of occurrence. They found Resna's dead body. Father lodged a complaint with the police station. Police recorded my statement during investigation. The cross part is important here, Lordship. Here, because I'm pointing out here, because your Lordship will find some other boys' names are also there. Because this is a case of circumstantial evidence. So if they want to prove those circumstances, it must conclusively prove towards us, towards me. In cross-examination, page 23, your Lordship will find the function was held in Kulojan. It is not a fact that while making statement to the police, I did not state that I had gone to watch the function. It is not a fact that while making statement to the police, I stated that I was at home. While making statement to the police, I stated that a person with the surname Das had come to our house on the previous day of the incident. So one of the person surname Das was arrested during investigation, but against him FR was submitted. None of us are with surname Das. That we had stayed in our house in the night. That he had differences with Resna over some issues. And that he had given Resna rupees 150 to drink tea, etc. in the function. I stated to the to police that my elder sister had elder sister had invited the person with the name with the surname Das to watch function in the evening. I also stated to police that another boy with the name Das from Panbari, so the second person, from Panbari Ghat had come to our house. I stated to police that another boy by the name Rahul Bora had told Resna that he loved her and would marry her. I stated to police that I had a suspicion that two boys with the surname Das and boy named Rahul Bora had killed Resna. So initial suspicion was against them. It is not a fact that Deepak had not called away Resna from the site where function was going on. It is not a fact that I have adduced false evidence in the court today. So what I am pointing out from this cross examination is that other person's involvement cannot be ruled out from this. So page PW 8. I am skipping PW 9 for a moment, Lordship Analysis, page 25. Other persons were also suspect named Prafulla Soikia. His motorcycle was seized and the PW 9 was witness to that. And PW 10 is the doctor who conducted postmortem. In the postmortem report, your lordship will not find any observation regarding sexual assault. So although
He had injury in the occipital region.
then PW 11, I'm skipping lordship. 12 also. 13 same, 14. Okay. PW 15 is the IO. Page 32. On 29/3/2012, I was serving as the in charge of CC Borgaon Police Outpost. On that day, upon receiving a written Ajahar from Sri Tuniram Dole, I made an entry in the general diary of the OP and sent the same to Silapatar Police Station for registering a case. Accordingly, Silapatar PS case number so-and-so was registered. I was entrusted with the charge of the investigation. I questioned the complainant and visited the place of occurrence. I drew a sketch map of the place of occurrence. Exhibit 7 is a sketch map. A girl was lying dead at the place of occurrence. There was mark of dragging the girl. I got the inquest done on the dead body. I sent the dead body to Dhemaji Civil Hospital for postmortem examination. I found a mobile phone with SIM card lying on the spot in a broken state. I seized the broken mobile phone and the SIM card. Exhibit 4 is a seizure list wherein Exhibit 4.3 is my signature. Material Exhibit 1 is the seized mobile phone. Material Exhibit 2 is the seized saw. And Material Exhibit 3 is the seized SIM card, which I recognize to be once I seized. Though Exhibit 3, the seizure list, I seized one LG mobile phone and a SIM card. Exhibit 3.2 is my signature in the seizure list. I recorded the statements of the witnesses. I arrested the accused and produced him in the court. So this is all his procedure, Lordship. Last part, cross, your Lordship, find last cross. While giving statement before me, PW Binod Pule did not state that he had seen Rosna Dole going out with accused Deepak. That's one of the circumstances that he state, Lordship, that in the middle portion of page 33, your Lordship will find. I arrested the accused and produced him in the court. I made prayer to the SP for providing call detection report of the mobile phone. It is out in the investigation. that the seized Airtel SIM card belongs to Deepak Gogoi. One motorcycle was seized through Exhibit 5 is my signature diary. I sent the vaginal swab to the deceased, so forensic it was sent. So only the call detection report. And PW 16, scientific officer, he stated that no poison was found. And PW 17, Lordship may and this is page 36. PW 17, I am presently serving as scientific officer in serology department at FSL Khanapara. So he examined and result of examination, exhibit number Sero so and Sero so gave positive test for human spermatozoa. Although the appellant was in custody, so but IO has made no effort to find out whether it belongs to him or whether there is any connection between this finding and between the appellant. Because it only says positive test for human spermatozoa. Whether the appellant was anyway connected, that is not there in the record.
But your mobile phone was found at this point.
No,
SIM
they
card.
have not found my mobile phone. They have found my call
Card.
detail, call connection with her. I have called her. That is their fine. SIM card. One SIM card that belongs to me. And now just I'm taking to the other documents your lordship will find. The inquest report. Inquest report, your lordship will find page 85. May I point out the relevant person? Page 85, the inquest report, your lordship will find here description of the dead body. It is written that her wearing apparels that was mentioned, and one middle portion your lordship will find that it was mentioned sandals with brown socks. In middle portion your lordship will find Police have, I have not found any severely subject to correction lordship that whether the wearing apparels were seized or not, that other inner garments. But your lordship will find in page 89. A pair of socks of chocolate color. So whether this is the same or belongs to some different person, it is not there. Because other her wearing garments were not seen. On the page 89, your lordship will find a pair of socks of chocolate color. Whether those belongs to the deceased or of other persons, that is not. If it is of victim, then what from my limited understanding, I found that inner garments or wearing apparel, those are first seized. Then it will go to socks, sandals, other articles. But here only I found that socks were seized, but others I do not find. Although it is of similarity, brown color and chocolate color, but it is not mentioned whether belongs to same or different. Because in the page 89, your lordship will find it is said that she is from the PO, not from the body of the victim, or that is not. Postmortem report, your lordship will find.
Just a moment. No, because that's why I was looking at the record. I missed it out initially. You see, in the inquest report, they say that the girl was wearing that brown socks. So naturally, these socks, which has been seized as material exhibit number 2 or B, whatever, is this socks only.
Other wearing apparels that were not seized, therefore I have pointed on.
No, it's okay, and when you'd expose it with the inquest report. This seized article belongs to the victim girl. But what is the connection is a separate question. It doesn't primarily establish anything.
My point before lordship was that if it belongs to victim, then I have nothing to say. But if it belongs to other person, that the involvement of other person is cannot be denied. Because if had it been a case of the had it been socks of the appellants, the police could have certainly raised that plea, that socks were found or other belongings were found.
Well, in a criminal case, we can't take notice of what you call. We can't go on surmises and conjectures. But from the inquest report, we find that the upper garment of the girl was brown or chocolate color. So therefore, it's a human tendency to match it with the socks also. And therefore, socks is again same color.
This is
So-
a case of
So it matches.
therefore.
It's a normal tendency. We are not assuming anything, but here it says socks is brown. So therefore, that connection.
Then this is lordship that which 87 your lordship will find one LG mobile number so and so, SIM card number so and so. From Deepak Gupta. And from place of occurrence, your lordship will find page 89. One Reliance SIM card where the following text is written. GSM number so and so, some broken parts of G5 mobile, a pair of chocolate color, sock of chocolate color. How these two mobiles are connected, what was the conversation, at what time, nothing is there on the spot. During the evidence of the IO, your lordship has found that he requested the SP to allow him to collect those details. I made a prayer to the SP for providing call detection report of the mobile. So what was the connection? What was the conversation? Those are not there.
I don't know, these things, normally the APP should report it to the police. Because you see, IO writing to a SP that please provide me the call details, as if the IO does not have power to call for that. These are nothing but laxity in investigation. The Assam Police Manual does not say that the IO for every matter will have to write to the Superintendent of Police to give him a direction or to give him a to provide him with documents. The Superintendent of Police is not his subordinate.
They can do their.
He's quite authorized to do it. He's an IO of the case. I think these are the matters, Ms. Bora, you'll have to write it down and compile a list and then flag it. You also make a note of this laxity in the investigation. Compile a list and give it that this has come to your notice, so that what has happened till today is okay. From tomorrow, this should not happen. IO is not supposed to write to XYZ and ask for authority to investigate. If he does so, we'll consider, if in the first blush, we find that he is incompetent as a IO.
Our lordship may really turn to page 3.
Because why only this? He will have to write to the SP also that at 10 o'clock in the case, in the what do you call, station diary, he will write 10 o'clock, entered the what do you call, Thana premises, sat on my chair. Now I am writing to the SP, please permit me to go out to investigate. The permission did not come till 5 o'clock, so my time has expired and now I'll go home and retire. Second day, he will write the same thing in the case diary. But at 10 to 5, he is in the office. SP did not give him permission to go out of the Thana, and therefore he is not involved in any law and order duty. He is not involved in any investigation. He is not involved in anything. But to sit in the chair, warm it up from 10 to 5, why not? This thing, please flag it down because I won't remember everything. Compile a list and then send it across so that these people can, what do you call, take cue from your report and then rectify certain things in the investigation. Just a moment. Yes.
Page 100 is the charge sheet.
100.
You will find three persons other than the present applicants are named at page 100, serial number 1 down below your Lordship will find. Lankeshwar Raj Rajbangshi, Devin Das, Ananda Raj Bangshi. And in the circuit, FR submitted against it. Now the circumstances which are relied on to convict me, your lordship will find at paragraph 28, that is page 73 of the paper.
Page 23,
Page 73.
73.
For one is on 23/3/2012, the victim, this is along with PW 6 and 7, PW 6, 7 and others went to Kulozan to enjoy cultural function on the occasion of Aliyah Ligang festival. Number two, the witness PW 6 and 7 in their evidence during trial. So here lordship will find that specifically it is mentioned in their evidence during trial. Because they have not stated in their 161 statement. First time they deposed before the court. Stated that while they were enjoying
Just a moment. There's a missing link. This motorcycle which was seized belonged to Pavitra Saikia, correct?
They have seized 2, 3 motorcycles. One that belonged to lordship PW 5. That in 164 your lordship will find that the bike which was taken by allegedly taken by the
Deepak Das.
Deepak Das, that was given by him, PW 5. That bike belonged to him, where the victim went along with.
Just a moment. PW5 is Binod Kuli. This is a bike which was his bike, taken by Deepak. But I am missing it somehow. Please come to that evidence.
That in the evidence it is not there.
It's not there.
It is not there. So that cannot be taken as a circumstance. Just for your lordship, as your lordship has asked, therefore I have pointed out to your lordship.
No, that's okay because there's a missing link. I'm not finding it. That's why I'm asking you. 111.
And seizure list is also there regarding the bike.
It doesn't help the prosecution because this statement says that the girl came back. No, going back is again no.
That clearly he did not say.
But that is not there in these statements. That's fine. No, I'll come to it because it was a missing link. I asked it. I'll come to you later on because if let him complete his part, otherwise I'll get mixed up.
Regarding that seizure of bike.
Just a moment. Just a moment. We'll resume at 2 because you see, this is intriguing me for a reason. Number one, now we have read this page 111. Here, you are trying to show that on this motorcycle, Deepak Gogoi, it does not say so. It only says that Deepak Gogoi took the girl on a motorcycle. Which motorcycle doesn't say. Now, this motorcycle, as per page 91, seizure list, is produced by Numal Gogoi. Numal Gogoi is the second appellant. Now, there must be some connection with the seizure, with the crime. There's a missing link. Please address us when it's your turn, because this is we find when the material exhibits are seized. Sorry, when the materials are seized through a seizure list, and it can't be connected with the scene of crime. But this is again one of the it will be a major lapse if it is so, because the seizure has to have some nexus with the crime or offense which has taken place. Here the witness in the 164 statement says that he has come back. Come back, then why is required to be seized? It's not an evidence of crime. Please address us when we resume at 2.
Was recovered from the house of PW11.
Recovered from the house of PW11.
Says Lordship, we do not know to whom this bike belongs or why.
PW11 is Kandarpa Tamuli. He is a seizure witness of Exhibit 5.
Of his house it was. In last case, I do not know as to whom the motorcycle belong and why police seized the same.
No, that's okay, because the police does not have to explain it to the witness why they are seizing it.
But he is a seizure witness.
No, it's okay. You see, the article of crime. Let us say the police comes and seizes this article. Doesn't have to explain to us why it's seizing it. It says that we are seizing it in your presence. We suspect it to be involved in a crime, and then you please sign it. So when I depose before the police, before the court, I'll say, I don't know why it has been seized. That is an information not required to be divulged. And in a criminal proceeding, until and unless this charge sheet is submitted, where I have read, I will not be able to recollect it right now, but this case diary remains in the custody of this IO. Nobody, even the Director General of Police cannot, by way of without a written note, cannot seek its custody to even to go through it. The police and all the circle inspectors, they have been assigned duties under the Assam Police Manual, but they will have to take it in accordance with law and then write their supervisory notes. Therefore, IO is not required to divulge the contents of the case diary even to a superior officer. Therefore, continue to. Yes.
Your Lordship was last previously said in 91 that regarding seizure of that motorcycle. And your Lordship turns to page 25. Your Lordship will find that one person named Populla Sogyagi kept that motorcycle. Page 25. Evidence of PW.
Yes, Profula Sakia. Yes, I have noted that.
That belongs.
Huh. But this is, you told us that this is a separate motorcycle.
Yes, because PW 5 says in 164 that the present applicant Deepak Gogoi took his bike along with the vehicle.
Oh, so this is contradictory evidence, which says that the motorcycle was left by Profula Sakia.
And ownership of that bike is not clear. So there are two things. First allegation is that I went along with the girl in a bike. Then I came back. That is the allegation, first allegation. And if two bikes are involved, subsequently with whom she went, how she went, that is not there. And the other witnesses who said who they saw me, they have not mentioned about the time. Whether they saw when I came back prior to that or after that second time allegation is there. That is not clear from the circumstances. Because in a circumstantial case, what I understand is that that they have to prove, they have to rely on the proved circumstances.
This, if I remember it correctly, this Profula Sakia was not examined. Profula Sakia was not examined. I'm just addressing other members of the bar. I think this will take some time because we propose to rise at 3 o'clock for the single bench. So the other matters may not be taken up in the division bench. Yes,
And if charge sheet also, my learned friend can verify it.
after the single bench will sit, after 3. Yes,
Step by taking your lordship to judge those judgments which I am relying on.
just give us 5 minutes. This coming back with this Deepak Gogoi is stated only by PW1. Yeah, any more witness?
PW five,
PW five? PW five in his cross-examination, yes.
now in examination in chief said that I saw accused Numal and Deepak along with the deceased guy.
Yes, yes.
And in cross, he denied the fact that.
No, I'm interested in coming back. That sequence is by PW one and PW five.
Six.
PW six. No, PW doesn't say that. He says, he doesn't say about return.
About return, no,
Only, I'm interested in PW five for that.
about return PW one and five.
One and five, huh? Okay. Then this return, who are the witnesses whom you say that they have not given the timeline when they went?
PW five and
PW?
five and six. 5, 6 and 7. 5, 6 and 7.
What are the other circumstances?
And reason of involvement of other persons in the present case, your lordship will find in the evidence across part of PW 7.
Yes, so these are four circumstances.
One aspect your lordship may rightly appreciate that from the evidence it comes that Deepak Gogoi and the deceased wanted to get married and therefore they went. This is the circumstance which they are in, if I am not wrong. And if that is so, then there is no motive to kill her. Also. They have not attributed any motive. If that is so, then I took her to get married. Because it was informed to the other family members, they also did not, they also not raised any objection to that.
Yes.
Your lordship has seen in across part of PW7 that other persons' names are also there. And in the charge sheet also, your lordship will find that 3 other persons were arrested initially. And when FR was submitted against them, only present 2 appellants were there in the dock. And therefore, the my applicant lordship, he was named first time in the court itself.
It shows that I'm not being able to follow you.
Charge sheet your lordship will find at page 100.
Yes, page 100.
3 persons down below your lordship will find name and address of accused person not sent up for trial, whether accused arrested. So they were, these 3 persons were arrested along with the present appellants. Lankeshwar Raj Rajbamshi, alias Rahul Bora. Number 2, your lordship will find David Raj.
These 3 were shown as absconder or not
No,
sent up
they were arrested and subsequently they were not sent up for trial.
because of lack of materials.
And only then my name is has been mentioned by the witnesses.
No, but still that evidence has come, we can't do anything. Because in the cross-examination was not dispelled. That as because other 3 were not put up, that's why you have named me. So that is not there.
It is not there, but when your lordship will appreciate the evidence of other witnesses, then certainly that fact can be taken into consideration because they have deposed.
You have yourself argued that surmises and conjectures in a criminal case cannot be inferred.
If that is there, then benefit will go to the appellant. And for that, I am placing.
No, you see, there may be tens and hundreds of accused persons. There's a mob attacking. There may be hundreds of people who are in the attack. One person is named. So there cannot be an inference that others were not sent up for trial, and therefore this is number 1 who has been caught and charge sheeted, or he has been prosecuted or named by the witnesses.
That is there, but my submission for lordship was there. when disclosing the name of other accused persons, they disclose that, they disclose the name of other accused person during investigation. But while deposing for the court, when the person were, whom they named in the initial stage, they were not sent up for trial, therefore they changed the name.
Yes.
Now I'm straightaway taking your lordship to the citation to the retiring lordship. The first lordship that I am relying on is Saraj British and lordship that 1984 4 SCC.
Vidishan Sharda is 2000,
1984 4 SCC.
84 for SCC, yeah, okay. Paragraphs,
Paragraph 153.
153.
53.
Yes, okay.
Just 5 principles, Borla principles. Just I'm reading the first one.
Not required because this is, you know,
Only I will read the first
153,
one.
huh?
Only I will read the first.
Hmm.
The circumstances from which the conclusion of guilt is to be drawn should be fully established. But here there are those, the fact that whether they were named earlier or not, those contradictions are there. Therefore, I am placing this. And second, I am relying on lordship 2014 4 SCC.
2014, what is the name of the parties?
Kathayala.
Two 2014 4 SCC
715.
715. 2014 4 SCC 715.
Paragraph 8, 12, and 15.
Para
8, 12, and 15.
yes.
So I am just reading the paragraph 12 and 15 also. The circumstance of last seen together does not by itself and necessarily lead to the inference that it was the accused who committed the crime. There must be something more establishing connectivity between the accused and the crime. Mere non-explanation on the part of the appellant in our considered opinion by itself cannot lead to the proof of guilt against the appellant. Paragraph 15. The theory of last seen, the appellant having gone with the deceased in the manner noticed herein before, in the singular piece of circumstantial evidence available against him, the conviction of the appellant cannot be maintained merely on suspicion, however strong it may be. or on his conduct. These facts assume further importance on account of absence of proof of motive, particularly when it is proved that there was cordial relationship between the accused and the deceased for a long time. The fact situation bears great similarity to that on censure. Then I am relying on, let's see, 2016, 12 SC. Lordship may straightway take up paragraph 12.
Para
Paragraph 12.
12.
Right law that a conviction cannot be recorded against the accused merely on the ground that the accused was last seen with the deceased. In other words, a conviction cannot be based on the only circumstance of last seen together. Normally, last seen theory comes into play where the time gap between the point of time when the accused and the deceased were last seen alive and when the deceased is found dead is so small that possibility of any other person other than the accused being the perpetrator of the crime becomes impossible. So here in my case, Lordship, that other person's names are there in the evidence of PW7 clause. So they have also they also have the motive. So whether they were involved or not, that part is not conclusively proved. And here, in my case also, the witnesses said that I came back. And at what time I went again, that is not there. To record a conviction, the last seen together itself would not be sufficient, and the prosecution has to complete the chain of circumstances to bring home the guilt of the accused. So except that, there is nothing in that. And the last citation I am relying on is Lordship 1994 Supply 2.
Uh, 1994 supplementary 2 SCC 372.
Yes.
Hmm.
Paragraph 31.
No, supplementary 2.
Yes, supplementary. Paragraph 31. Party's name Arjun Mari. Here also the same principle that only last seen theory will not complete the chain of circumstances.
Para
Para 31.
31.
Thus the evidence that the appellant had gone to Sitaram in the evening of 19/7/1985 and had stayed in the night at the house of deceased Sitaram is very shaky and inconclusive. Even if it is accepted that they were there, it would at best amount to be the evidence of the appellants having been last seen together with the deceased. But it is settled law that the only circumstance of last seen will not complete the chain of circumstance to record the finding that it is consistent only with the hypothesis of the guilt of the accused, and therefore no conviction on the basis alone can be founded. That is it. One citation, your lordship, I have given that Indrajit Das. Supreme today, lordship. Here it is equivalent citation of AR is also there, lordship. Paragraph 15. This is only regarding that motive part. Paragraph 15. In a case of circumstantial evidence,
Paragraph
paragraph 15.
15.
1-5. In a case of circumstantial evidence, motive has an important role to play. Motive also have a role to play even in a case of direct evidence, but it carries much greater importance in a case of circumstantial evidence than a case of direct evidence. It is an important link in the chain of circumstances. Reference may be made to the following judgment. So those two citations were relied on. And another judgment also which I have placed to lordship is that Azizul Haq, that already on the other day also I have placed to lordship. The paragraph 45 and 46. That Sharad British was discussed. Only on that aspect. The chain of circumstances is not complete in the present case.
And what is this Azizul Haq?
Azizul Haq, paragraph 45 and 46, Sharad British discussed and
Acha.
the circumstances must prove that ratio is there. Must or should and may not be established. Sir, since my friend has already covered the entire factual part, my lord, I'll not take a lordship again to the facts.
No, if you're okay, factual matters, okay. And here you take this back. I think you'll have to correct it. You've given some different appeal number. In that,
My lord, I completely adopt the submission made by, and I'll just add 2 or 3 points, madam. My lord, this is a small write-up which I have submitted, my lord. This is what is the evidence against my client that emanates from the records of this case, my lord. Numul Gogoi. There are 4 pieces of evidence.
yes.
My lord, a small write-up, my lord. These are the 4 places where my name figure out in the entire record, my lord. Number 1, PW1, my lord, that's the informant or the father of the victim. He at page number 11, these page numbers are of the paper book, said that later I came to know that 2 persons, Numal Gogoi and Deepak Gogoi had killed her. This is the first place where my name appears, my lord. Now, with respect to this, my lord, what I submit is that firstly, PW1 is a hearsay. And secondly, there is no indication in his statement as to from where he has come to know about the name of the appellant Numul Gogoi. Further, he had failed to recognize the appellant in the dock. The second time my name figures out is in the statement of PW2. That is the brother of the deceased, my lord. He says that in connection with Rasnath, that police arrested 2 persons, namely Numul Gogoi and Deepak Gogoi. My lord, this line, in my limited understanding, my lord, in no way helps the prosecution because there is no implication of the appellant in the offense as far as this line is concerned, my lord.
This first part of your argument, I'm not able to follow. You say that PW1 failed to identify him in the dock. Please expand it. What do you want to say from that?
Now, my lord, I say a particular witness is testifying that X and Y has killed my son, and he is naming them. But at the same time, when these 2 persons are standing before him in the trial court, my lord, he's not being able to recognize whether this is the X or this is the Y. Therefore, this naming of X and Y is completely based on hearsay. My lord, if I say, my lord, if I say that
No, you see, when we are reading in English, a bit change of words and language conveys a totally different meaning. Correct. The question asked is, do you know accused persons? And he says, I do not know the 2 accused persons in the dock. Correct. Now you see, there is a question asked. Do you know him? I don't know him. The question was not asked whether these are the accused who had committed the murder. So you see, identification is of the crime, not of a person. You ask him a question whether I know him. Let us say that let us name a politician in another country. Correct. Now the question asks whether you know him. I said, "No, I don't know him." Second question is, have you heard of him? I'll say that yes, I have heard of him. Third is whether you have acquaintance with him. I'll say no acquaintance with him. Now, the fourth statement is whether you have heard in the TV that he has made this derogatory statement against India. I'll say that yes, I've heard in the TV report of that. I've listened to him. So you see, a change of perspective in the question which is being asked. Do you know him? Definitely, I don't know an accused person. Now, there's a second aspect to it, with which we are affected, and therefore you don't find judges mingling in the crowd. Now, let us say that in a particular forum, there's a photograph taken of me with you. Correct. We are in a dais in some program organized by you, and then this has happened. Now let us change the situation. We don't take ourselves as a example. Now let us say A and B, their photographs have taken in a forum where A is the president and B is an invitee, and a photograph is taken. Now the question asked is that now B is, let us say A is involved in a crime. A or B, either of them is involved in a crime. Now the question asked is that, look, here is a photograph of both of you together. Do you know him? Now what would be your answer? You see, if it's only a language. If it's an alert person, he will say that, well, I had an acquaintance with him, but I don't know him. Correct. There's another aspect. You see, when we have these references and we go to condole a death of some person, we say he was a nice man. Now, is this statement made when you go and pay an obituary to a person who has expired that he was a nice man? Is it, if I ask you a question, do you certify that he was a nice man? And what would you say? You see, it's a question where when you don't know about anything about somebody, that means you don't know either the positive or the negative. Therefore, you say he's a nice man. Nice man does not mean a certificate from you that he was not involved in any crime. Correct. So if I am to understand your meaning, I have to understand it in the perspective of the question asked. The answer is, I don't know the accused persons. So I don't know him.
What present in the doc?
No, in the doc, I don't know him. But his question was never asked whether they are the persons involved in the crime. I would have said yes.
Now, my lord, subject to correction, what I understand is that, my lord, in a trial, this doc identification is that in order to.
No, identification in the doc is not an identification at all.
Absolutely.
Because of the fact that everybody knows that he is an accused person, he has come with a hand tights.
Yes.
He is put into the dock in a special what you call enclosure, and therefore everybody knows who's acquainted with the court system that he is the accused person. Correct. So that identification, if you ask a question, if I ask myself a question that whether that is an appropriate identification, no. Under the Evidence Act is the TIP, which is a conclusive evidence of that. So I don't see any meaning in this statement.
My lord, even I'm not making it a very substantial argument because otherwise also admittedly is an hearsay evidence, my lord, because it's
That's okay, huh?
otherwise
Yes,
also
that's okay.
will not connect the accused with the crime.
No.
Then, my lord, again, PW2, I'm just, my lord, what my purpose of jotting.
No, I'm trying to understand. You see, you made a proposition, I'm trying to understand.
Yes.
That is one way of it. Second way of it is that although I'm an impulsive, talkative person, but you see, the second aspect is that I can always be like a statue and then hear you and then end of the matter.
It is always a learning experience to argue before.
No, it's not that. I'm just telling you. You see, that can be an alternative.
No, my lord, in the bar, my lord, we enjoy interactive sessions because this gives us an opportunity to understand also.
Yes,
And if
that's what I think.
anything, probably your lordship is thinking in a particular, that also gives us an opportunity to impress upon your lordship that probably there is other.
There's another angle of it. Yes, right. Absolutely, I'm with you.
So, my lord, PW1, as far as PW1, that is, my lord, that does not help the prosecution in any way, my lord. PW2, the same thing in connection with Rasnath as death, police arrested 2 persons. This is also neither here nor there, my lord. No implication in this statement as well. Now, PW 5 and Exhibit 5. PW 5 and Exhibit 5 are the other 2 places, my lord, where my name figures out. Now, PW 5, my lord, verbatim I have quoted in that write-up, my lord. PW 5, what he says at page number 18 is, I saw accused Numal and accused Deepak along with the deceased girl at the site. On the day of the incident, the girl left the site of the function along with the accused doe in a motorbike. Now, my lord, already, my lord, my friend appearing for the other accused has submitted that there is a confusion as to whether this statement is in relation to the first time when they went out or after coming back when they went, but there is no clarity to that point. The other thing is that, my lord, out of the 3 prosecution witnesses who were present on the day, that is PW 5, 6, and 7, only PW 5 names me. PW 6 and 7 is absolutely silent about me, man. Now, my lord, furthermore, my lord, because this statement somewhere brings the theory of last seen theory, my lord. Now, my lord, in the statement of PW 5, because from the statement of PW 5 that last seen theory comes in, my lord. Now, my lord, in a last seen theory, the time assumes some importance, my lord, to whatever judgments I could lay my hands on, the time is. Now, interestingly, my lord, in the statement of PW 5, my lord, there is no time is mentioned as to when he has seen them. They went out. Now, my lord, because this is vague, as no time, and even the date is also not mentioned, only 1 year is mentioned, 2012. No time, no date is mentioned in that, my lord. Now, my lord, in this regard, my lord, the other place where my name appears is Exhibit 5. Exhibit 5 is that exhibit through which a motorcycle was recovered, my lord. My lord, may kindly come to that page, my lord, for a while, page number 91. My lord, is there at page 91? Now, my lord, we see the language of page 91. What does it say? I, the undersigned, do hereby seize the below descriptive motorcycle on being leading and produced by accused Numal Gogoi. Now, my lord, if it is leading, my lord, then there has to be a disclosure statement under section 27. Now, my lord, there is no disclosure statement which has been exhibited in this case, my lord. There is no disclosure statement. Now, my lord, the full bench of this honorable court, in a reference made with regard to whether it is mandatory that disclosure statement has to be in writing always, the full bench of this court has answered the reference in this way, saying that it is not mandatory, but some witness must testify exactly what the accused have said, so that it gives an idea to the judge that as to what was that particular statement, as a consequence of which some discovery was made. Now, in this case, there is no witness who had testified as to what Numal Gogoi has said, because I am making this submission, my lord, because the word leading and produced is used, my lord. Now, my lord, rather the evidence is otherwise. The two witnesses who have signed this particular seizure list are PW 9 and PW 11.
Just. Yes.
The vernacular probably, Your Lordship. Yes, even I was trying to see that what is written in the vernacular.
तलब exhibit file में लिख के हो यार A तलब exhibit file हो In English. This was in English.
Therefore,
We have to do all of this.
You have to कोशिश करें
सभी से कोई-
कोशिश
but otherwise, my lord,
करनी चाहिए
Next date will be 29th. Right? You have to write separate orders, 2 appeals. Huh? In 252, right? The submissions of Mr. A. Azad, A. Ahmed, counsel for the appellant, is concluded, reserving right to reply. Ms. S.H. Boral and APP is present. Due to positive time, that could not be, hearing could not be concluded today. Next para, list again on 29/1/2024. In appeal 184, here you write, submissions of Mr. M. Biswas, counsel for the appellant, remains inconclusive. Ms. S.H. Boral and APP is present. List on 29/1/2024.
as a part of
Not as pattern method. In both, say pattern method. Your list. Okay, but you'll have to convince us one more aspect if that is stated. You see, first is that in most of the cases where when we look at the trial and whatever is coming us, I am not saying a general remark, but I am making a remark specified to the cases we have handled till now. You see, in a cross-examination, what was the actual text of the statement made in 161 are never revered. At least I have not found anything. Therefore, as an extension of what I am saying is, how we determine that what is being stated in the court is for the first time uttered in the in this court evidence and was not stated there in the 161 statement. Let us say in a statement, a witness says, you're a defense lawyer, you are accosting this witness, PW1, to a question that you did not say this to the police. Correct. And he gives a reply either yes or no. I did not say before the police, I did not say before that. Now, this part of this evidence of 161, you had a copy as a defense lawyer. You don't reproduce it verbatim. And therefore, the contents of statement made under 161 is not before us, number one. Second, if you look at these criminal code rules and orders, I can identify those paragraphs. Here, you will find that there is a specific statement made. Just give me 1 minute time because you see, one of these provisions says the list and the documents referred to them shall not be attached to any file while the trial or inquiry is proceeding. When hearing or trial of inquiry is over, the lists shall be numbered with their proper serial and sheet numbers and shall be affixed to a file to which they belong in their proper places. The necessary entries in that connection in the list shall be in the table of contents. Number one, this would mean that a document which is not exhibited will not form a part of the file. It will not go in any file, but as a matter of practice in our criminal courts, those are entered into B file. That is one. Second, yes, in another chapter, you will find that documents not admitted as evidence. Documents which are not admitted as evidence should not be made a part of the record, but should at once be returned to the party to whom, by whom they have been produced. Documents filed by a party to the proceeding but not admitted in evidence, if not returned earlier, shall at the conclusion of the proceeding be returned to the person producing them or advocate or pleader. And at the last time, omitting this, it's a big paragraph. The last part says, they shall not be sent to the record room. Correct. Now, there's a corresponding entry in the police manual. According to the police manual, which is corresponding to 173 in the CRPC, says, I'll just refer to that. Both is a report of a police officer in completion of an investigation. There, what documents are required is mentioned. And it says whenever the court wants, it can call for the case diary. Correct. So the case diary does not form a part of the evidence and it should not come into the record. Assam Police Manual also says case diary is to be produced before the court only if required. It's a wrong practice going on in the state of Assam where the case diaries are produced. Now under the CCTN 5 format, those have been now omitted. Now case diaries do not come to the courtrooms. So therefore, this is the practice. Now, if a document is not a part of the record, although a case diary may be available in the record, but I am prohibited from looking into it because it does not form a part of the trial court record. Number one. Number two, parties have no notice about the reliance of those documents at the hearing at the appellate stage. Second. Third is that the APP is not been given an opportunity to take an instruction as regards that part of the investigation because the link between the investigation and the appellate stage, the link between the two has snapped. Correct, the three things operating. Now, therefore, unless you bring on record what is the appropriate evidence, because you see, you can, under the Evidence Act, one can be asked, given a document to refresh the memory. And when you are asking a question to a witness that whether this you did not say before the police, then you are not putting him that part of the, in none of the cases I have dealt with till now. I have seen a perfect cross-examination where you refer to that CD and you say them to tell the witness, look, this is the earlier statement you have given by the police, acquaint yourself with this and now answer whether you have stated this statement with the police or not. I have not come across such type of cross-examination. Therefore, the idea to show you all this is to the effect that unless that positive evidence is there before the court, you'll have to satisfy that this is an aspect which will, despite the judgments which you are trying to show, is a relevant factor for our decision. Correct. So this is only a question which you are putting. I'm only giving the background why I'm stating so. And you can take my word for it, but that is something which I am acquainted. Assam Police Manual also requires that CD is not to be sent to the court. Correct. If you have any doubt, we can next time on the hearing I can show you that also. $30. Yes, no issue with that. 30. Make it 30. Because at the stage, in my grooming up stage, when I know the work, this was the thing I was reading. Huh? No, that's okay. But this is something.
One criminal appeal I did pertaining to UTR court in Arunachal Pradesh. They quote verbatim within inverted commas. I did not state before the police verbatim.
That is the correct idea, the correct way of doing it.
They confront the witness with the case diary.
Correct. That is the
The case diary they read and verbatim it is quoted.
Yes, that is has to be.
And the best, and there is another advantage is that it is in English. So what is stated, reflected, there is no.
No, in fact, when you have made that, I can give you a statement that insofar as the investigation is concerned, the quality of investigation in Arunachal is better. It's a general statement I'm making, not a specific statement. In one case, maybe there is a fault, but by and large, the correct pattern of investigation is reflected in their case diaries in Arunachal Pradesh. I can I'm not comparing it with the, what you call this, conviction ratio. But the satisfaction on looking at the case diary is more when we look at the case diaries in the state of Arunachal Pradesh. The impugned order is set aside as an interim measure. This maintenance of 15,000 from the month of February 2022 has to be paid till February 2024. The award of maintenance by the trial court shall prevail over this interim direction. Petition number 333 of 21, which is miss case number 5 of 2021, is restored back to file. The petitioner is permitted to raise a plea that he has not been served a copy of the miss case, which shall be decided in accordance with law. Yes.
Item 2. Number 4.
Yes.
I'm paying on behalf of the BP Sinha, madam. He is for the other respondent side.
Okay.
He
Has the document been produced? You got the documents? Because we can't adjourn for long. We have been adjourning this for about more than a year. Okay, because the documents could not be retrieved. I think we have already given a last chance. Item 4. We're just adjourning it. We are not saying anything because in the last order, we have made it clear that if relevant records are not produced on the next day, the court would proceed to hear the matter on the basis of materials available on record. We're not diluting this. Just on his prayer, we are adjourning the matter. Mr. I'm sorry, I forgot the names. And Mr. A. Chakravarti, Learned Government Advocate, is present. On behalf of Mr. B.P. Sinha, counsel for the respondent number 1, prayer is made by Mr. M.K. Bhagavati, Learned, M.K. Mishra, I'm sorry, Learned Counsel for the Learned Counsel, that the counsel holding the brief is out of session, and therefore he pays for a short adjournment. Prayer is allowed. Let's give a date after 2 or 3 weeks. Give it 3 weeks so that he can do, if he can get the order.
Sixteen of 6th February. Oh.
16 to 2024. Mrs. Chakravarti, we are not diluting that order. Item 2.
Lordship, with the concern of the other side, and therefore adjournment, Lordship, for 2 weeks, Lordship, machinery is out of station.
Okay. Mr.
T. Roy, Lordship.
D. Roy, counsel for the petitioner, praised for adjournment on the ground that his the counsel holding the brief is out of station. Miss M. Dekal and APP is present. List after 2 weeks, give a date.
Obliged, Lordship.
So item 3.
Lordship, I intend to withdraw that mistake, please, Lordship.
Going to withdraw this. Okay, Mr.
Kate Hub.
A.
Kate Hub.
K. Thakur, learned counsel appearing on behalf of Mr. D. Mehdi, counsel for the petitioner on record, come upon instructions raised to allow him to withdraw this application. Miss and thus learned APP is present, so the prayer is allowed. This application stands dismissed on withdrawal.
Item 5.
Yes.
Was forwarded in 2012. The rest is very report by and it's of yellow flag. The below credit is disclosed regarding financially of the regulatory before it's
Mr. Aman, I just forgot the context. The bail was obtained in connection with the
on bail was pending for
yes, that is bail application number 2622. So this
bail application. They preferred another bail application is 26248. Before my lord
and in 2648 they got a bail.
they got a bail.
So therefore this matter has to be taken up for cancellation of bail. It will go to that court.
Here I'm going to file an application.
No, it's okay, but this has to be tagged there.
Yes,
Okay.
and it may be tagged with my note BA number 4616 2020.
BA
BA number 4616. It is not there, my lord.
no BA is another bail application.
No, I filed an application, BA number 46 for cancellation of bail. On the ground that.
No, but how can we list it as BA?
No, initially I filed IA, and Honorable says, no. You have to file BA under section 49(2). Then I withdraw, then I file.
Okay. Okay. Mr. F.K.R. Ahmed, counsel for the applicant, learned counsel for the applicant, as well as Miss M. Das, learned APP for the state, respond number 1. Pursuant to order dated 2012-2023 passed by this court, the registry has made an inquiry and has put up an office note dated 5/1/2023 comma, inter alia, comma, indicating that from the record of BA number 2648 of 2023, comma, the respondent number, the opposite party number 2 herein, comma, namely Sri Suraj, Suraj, Sen, Sen, had made no disclosure therein about the pendency of BA number 2622 of 2023. It is also mentioned therein that it said Suraj Sen had not filed BA number 2622 of 2023, nor did he file BA number 2648 of 2023. And those applications were filed by Srimati Pooja Sen, within bracket sister-in-law, and Srimati Geeta Devi Sen, within bracket mother, respectively. Full stop. Next para, as this court finds that there is a serious and tribal issue regarding non-disclosure of correct facts relating to pendency of previous bail application. I.e. about pendency of BA number 2622 of 2023, comma, when BA number 2648 of 2023 was moved, comma. This would be an appropriate case to have an inquiry made. IPC dio. inquiry is as to whether the opposite party number one, namely Suraj Sen alias Chotu, and the deponent who has sworn an affidavit in BA number 2648 of 2023 have sworn a false affidavit in support of BA 2648 of 2023 so as to create a false evidence and giving false evidence with an intent to procure bail and using such evidence known to be false as well as making of a false statement made in a declaration which is by law receivable as evidence, which constitutes offenses under section 195 so sorry, for sections 193 to 196 IPC, section 199, just like that, not 193 to 196, 199, 200, 205 to 211, and 228 IPC. Full stop. Next paragraph. It is made to appear from this interlocutory application that by making a false statement of there being no pending bail application before this court, bail was obtained by a coordinated bench of this court in BA number 2648 of 2023, this court is of the considered opinion that this would be an appropriate case for having this interlocutory application being listed before the same honorable bench which had passed, which has granted bail in connection with bail application number 2648 of 2023. Full stop. Next paragraph. Accordingly, the registry shall examine this this matter and with prior permission of Honorable the Chief Justice, list this matter before the concerned appropriate bench. Next paragraph. The learned counsel for the applicant has submitted that he has also filed an application for cancellation of bail, which has been registered and numbered as
4616.
BA number 4616 of 2023, which is filed under section 439(2) of CRPC for cancellation of bail. But the registry shall examine that, it will strike out, so it is submitted, and therefore let this application be tagged along with BA number
4616.
4616 of 2023,
It's fixed on 9th of February.
comma, which is fixed on, is stated to be fixed on 9/1/92/2024. Okay.
Right.
Item 6.
Yes.
It's IA in pursuit of WBC number 3561. Which was disposed of in motion state by order dated 21/6/2023. But can we say
Where is that order page?
81,
Page 81.
page 81.
Yes.
In this order, page last, this writ petition is then disposed of with liberty to the petitioner to apply for fresh connection to answer. As this order has been passed without issuing notice on the respondents are at liberty to apply before this court for modification of the order if so.
I did not notice them.
There opposite party here. So, madam, that the dispute is essential between the private respondent.
No, whatever be, but once we have allowed them a liberty to approach this court, will issue a notice, let the other side appear.
Yes,
Who is the counsel for the, in the writ petitioner, who is the counsel? You, Datta. Okay. Mr. M.H. Chaudhary, counsel for the applicant,
Yes.
as well as Mr. A. Barwal, understanding counsel for the APDCL. In terms of leave granted by this court in order dated 21/6/2023, passed in WBC 3561 of 2023, the present application has been filed by the applicant, was arrayed as respondent number 7 in the connected writ petition. In the disposed of writ petition, being WBC 3561 of 2023. Next one. The registry shall list this matter on 29/1/2024 by reflecting the name of learned counsel, reflecting the name of Mr. U. Datta, learned counsel for the writ petitioner, as counsel for the opposite party number 1, while listing the matter next. Next, in the meanwhile, the learned counsel for the applicant shall serve a copy of this interlocutory application to Mr. U. Datta, counsel for the writ petitioner in WPC 3561 of 2023. You serve a copy to him. We'll take it up on Monday next.
I have been fair also.
Interview, we're not passing it right now. No ex parte orders. You should have given the copy, advance copy to them. You would have taken up the matter. Ex parte orders. You know what happened after I passed an ex parte order? Now you are here. I pass an ex parte order, then he will be here. Correct. I don't want these things. Okay. Mr. Sheikh? No, no, no. To the lawyer you give it. Why registered post?
Yeah, but and deputation is the course of my work. We will try to solve to the lawyer. In addition to.
No, no, that is not required. That is an unnecessary exercise. You see, when you have time, you read the order 3, rule 4.
I have.
Correct.
It's continuation of.
It's a continuation of proceeding. And the similar, what you call, provision is there in the High Court rules. It will be 60 or 61. What is that?
I got rule, my lord.
Yes, yes. Chapter 5. This appearance of lawyers, there's a reference to order 3, rule 4 in the High Court rules.
Right, my lord, let me check and find out.
No, 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 no. It's here.
I put it in the election 2010. Guwahati High Court conditions of practice of advocates rule 2010.
Is it there?
It's fine. Get a PDF.
It's there somewhere.
Maybe
Rule number 9.
Rule 9. Thank you, Mr. Barua, for doing that research. Guwahati High Court,
High Court conditions of practice of advocates 2010.
chapter 10.
Rule 9.
2010. Rule 9.
Please read that. What does it say? I'm not getting it.
Rule 9(1). Civil cases, the appointment of an advocate unless otherwise limited shall be deemed to be enforced to the extent provided in their behalf by Rule 4 of Order 3 of CPC.
Yes,
It's linked down.
this links up.
Lots of-
And second thing, the Guwahati High Court rules. Interestingly, this writ petition is a civil jurisdiction.
But civil jurisdiction, but there is some problem about other proceeding in CPC. Other proceeding.
No, this is not a civil proceeding.
220.
No, this is not a civil suit. You see, there is a difference between civil proceedings and a civil suit. In civil suits, there's a mention of miscellaneous proceedings, and it doesn't cover Article 226, correct? And what is a miscellaneous case? You will find in the civil court rules and orders at the end of the almost at the nearing the end of that book, you will find miscellaneous cases. And in miscellaneous cases, about 11 cases are even bifurcations are made. Those are referred to as proceedings, miscellaneous proceedings.
CPC man.
In civil court rules and orders, there's a miscellaneous proceeding. What is a miscellaneous proceeding is described under the civil court rules and orders. 11 items are listed, and those are proceedings within the meaning of CPC under 141, which excludes writ petition.
What's of it? I have stopped in the other proceedings in the CPC mentioned.
No, I'll show you
Other
that.
proceeding does not include this
No,
here.
no.
It's
I'll show you that.
226.
No,
But
no,
what your lordship pointed out, that is another aspect that I have not examined that part.
no. No, I'm wrong. 18. Yes. Let's show it to Mr. Sheikh. Yes, miscellaneous proceedings. Right side, yes.
Miscellaneous judicial cases.
Yes, now there are 18 numbers of cases. I said 11, I stand corrected. Correct. These are miscellaneous cases within the meaning of CPC. And this does not include Article 226. Next is cases under the other acts.
Other acts.
Yes.
Yes, sir.
So this also does not include Constitution of India 226. Therefore, exclusion under 141 CPC is correct.
Yes, sir.
But still, writ petition is a civil proceeding.
But we are on the point of this. Where from we start, my daughter, I have forgotten.
We have started from miscellaneous, the lawyer having a brief will include his authority in appearing in the miscellaneous cases. That is one
there,
part.
But I refer that other proceedings will not include 226.
Correct.
Yes, sir.
That is the law. I'm showing you this. It doesn't code it, but still writ petition is a civil proceeding. But it is not other proceedings within the meaning of 141. Correct.